Good afternoon. Welcome to Based in Fact, a true crime podcast. We're your hosts, Lisa O'Brien and Kyle Evans, and this is episode 4 updates. We will talk about the status of and or new developments in some of the cases we've covered during seasons 1 through 4, including Oklahoma versus Glossip, Oklahoma versus Hanson, Texas versus Reed, Texas versus Roberson, Arizona versus Jodi Arias, and Florida versus Dalia Dippolito. We'll talk about the status of Glossop's retrial, Hanson's transfer to Oklahoma for execution, Reed's challenge to Texas DNA testing statute, and his efforts to file successive habeas claims in federal court, the upcoming evidentiary hearing in Roberson's case, and recent developments in the KFC murder case that identified a third suspect in the robbery homicide. Spoiler alert. And I apologize for that little bell. I was trying to adjust my volume on my headphones at the wrong time. So, and good afternoon, Kyle. How are you doing on this lovely Sunday?
I'm doing great. I feel like the apocalypse is moving in here in the Dallas area. We've got some high winds and weird skies, so I
Uh,
am hoping this is not the apocalypse.
yeah, it's 80 today, and it's I think going to be in the 40s tomorrow.
Yeah, that's exactly right. Yeah, though it's winds blowing, and yeah, it's supposed to be like 35 overnight. It's crazy. Welcome to the
Yes.
weather.
So, and also I wanted to ask you, that shooting of Jasmine Crockett's security guy. Did you
Oh
hear
yeah,
about that?
I did hear about it. I don't know. That was. I think that was. I'm a little bit north of Dallas, but I think
Okay.
I don't. I saw it, but I. That's about it, to be honest. I know it was a thing, but yeah, it was a little bit of ways from us.
Okay. Yeah. I think it was in Dallas,
Yeah,
city of Dallas.
So a little bit of ways from us,
Okay. I
but
was hoping you'd
yeah.
have the scoop as to what happened. I mean,
I
what
know.
triggered.
I wish I had, but I'm sure. I mean, knowing Jasmine Crockett, it could be anything.
Yeah.
Which I'm
All
really
righty.
disappointed she didn't win the Democratic primary in Texas. I was really looking forward to her campaign. I'm afraid that well, she'll probably get a job on MSNBC, but otherwise, I think this may be the end of the line for Jasmine Crockett, unfortunately. She was so much fun.
Yeah. Although I heard Tallarico's a nightmare. So
Yeah,
I'm
he's
hoping
pretty
for the
kooky.
Republican.
He was a little kooky. He actually might be more kooky than her. And I mean,
Yeah.
sorry, I apologize for my listeners, but just as a side note, I think it's funny that for all the people that called anyone who didn't vote for Kamala Harris racist and sexist, it is funny that the whole Democratic establishment and money came out behind the white guy and completely ignored African American female poor Jasmine Crockett. So it's like, wait, I
And
guess you guys
well,
are actually racist and sexist too,
this
right?
this is how crazy Jasmine is. This was a Democratic primary, and yet somehow she lost because of Donald Trump and Republicans,
Yeah, exactly. Yeah, exactly.
which she never explains. She just cried about it, but it's like it's another Democrat beat you. And from
well,
what I
and
understand, it was pretty significant.
and not to go way. I mean, we're all the way down the rabbit hole, but it's like everybody's like, oh, if you question, remember in what was it, 2020? Oh, if you question election results, you hate democracy and you're, I don't know,
Mhm.
somehow
Mhm.
evil. And of course, she was just like they did in Georgia with Stacey Abrams. She's like, oh, the election was rigged, not
Yeah.
fair, they stole it.
Yeah.
So I guess it
All
really
right.
just means if you're not a Democrat, you question the election results, you're bad.
Yeah. It's the old rules
Yeah,
for thee, but not for me.
yeah, exactly.
All right. Well, let's get started on our updates. The first case we're going to look at is Oklahoma versus Richard Glossip. His victim was Barry Allen Van Treese, 54, and he was killed on January 7th, 1997. Of course, at Glossip's first trial, he was convicted, but that conviction was reversed on July 17, 2001 on direct appeal. His second trial, he was convicted on June 1st, 2004 of first-degree malice murder, and he was sentenced to death on June 3rd, 2004. That direct appeal, his conviction and sentence were affirmed. His appeal to the U.S. Supreme Court was denied. He had multiple state court post-conviction writs, applications, I think is what they're called in Oklahoma, none of which were successful. He had a federal petition for writ of habeas corpus to the U.S. District Court in the Western District of Oklahoma. Relief was denied, and that decision was affirmed. He also has been before the U.S. Supreme Court multiple times. He challenged denial of his federal habeas claim. He challenged Oklahoma's execution method at the time. He also challenged the denial of several of his state court writs. He won a stay of execution in 2022. And as we all know, ultimately, the U.S. Supreme Court vacated his conviction and remanded it back to the state courts in Oklahoma for a new trial. And first, I want to say, even though he has a new trial pending, and I probably will not talk about the case again until that trial and direct appeal have concluded, I don't owe him a presumption of innocence. And so I'm not required, because he's waiting for a new trial, to presume he's innocent. We can rely on the prior trial and the evidence we're aware of to have our opinion. It's only my opinion.
Yeah, exactly.
And if you're in Oklahoma, I would ask that you turn off this portion of my show so that I don't, potentially influence you if you're an Oklahoma City, Oklahoma County resident. Please don't listen. Take everything I say with a grain of salt. Okay, so we have, while the writ to the U.S. Supreme Court was still pending, because that was not granted until January 22nd, 2024, Don Knight wrote an email to Gentner Drummond, who I will never forgive for what he did in the Glossip case. And basically, he was proposing a terms of settlement of the case against Glossip, of the criminal charges against Glossip. He was advising that his team was preparing a document for Drummond's review to memorialize the full terms, but he laid out a list of terms. Once the conviction is, and I'm just going to read them word for word, because this man has, it's a wonder he can walk because of the size of his cojones. Okay, it's a wonder he can sit, walk, do anything.
They're bigger than his brain. Right?
And if I have to explain that to you, I'm sorry, I'm not going to.
The PG-13 portion of the show will
yes.
begin.
Anybody who's had an older gentleman relative, ask them what I'm talking about. Once the conviction is vacated and the matter returned to the OCDC, the OAG will continue to prosecute the case on behalf of the state. So this is funny, because when Drummond agreed to continue prosecuting, Knight actually was upset about that, because he had a commitment from the Oklahoma County prosecutor not to even prosecute Glossip. So he didn't like that outcome. Number two, since the conviction will be vacated, the state will file new charges against Glossip on a single count of being an accessory after the fact, the maximum sentence for which in 1997 was 45 years. Mr. Glossip will plead guilty to this charge. The parties agree that Glossip will receive a sentence of 45 years in the Oklahoma Department of Corrections. The state agrees to give Glossip credit for all the time he serves from January 10th, 1997, through and including the date of the entry of his guilty plea and sentencing. In addition, the state agrees to give Mr. Glossip full good time credit as if he was an enhanced level 4 inmate for each day he has served in custody. The parties stipulate and agree that with this credit being applied, Mr. Glossop is eligible for immediate release as his sentence was completed in 2016 under those sentencing terms. Mr. Glossop, upon entry of the plea and sentencing, which will be completed in a single proceeding, will be immediately released and will not be placed on probation, parole, or post-imprisonment supervision. He will not be required to pay any fines, costs, or fees associated with this case. He will not be required to pay restitution as a result of this plea. The state of Oklahoma will have no further right to claim any time or anything of value from Mr. Glossop resulting from the events that began January 7, 1997, and continue through the date of his plea and sentencing. Glossip will agree to fully and forever release and discharge the state of Oklahoma from any and all actions, claims, causes of action, demands, or expenses for damages or injuries, whether asserted or unasserted, known or unknown, foreseen or unforeseen, arising out of Glossip's arrest and incarceration. It is understood that the state of Oklahoma, nor any agency thereof, admits any liability in this matter. Now, this tells me, in addition to Knight's humongous cojones, he also thought the fix was in.
And this is just his request, right? This is just his.
These are the terms he's proposing.
Oh, gotcha.
He also advised Drummond that he intended to contact the PPB to request that the clemency hearing on April 12th be continued to a closer date, closer to the 5/18/2023 date. So this is when Glossip still had a pending execution date.
It seems like the only thing missing is for Glossip to be named governor of Oklahoma.
I know, really. So then Drummond and Drummond, this shows what a horrible attorney he is. Because he sends a response back that says, "We are in agreement." Not, "Hey, look, I want to look at the proposed, final settlement. I want to review it. I'm not going to commit to anything." No, he just says we're in agreement, which was actually a response to another part of the email. So probably to continuing the hearing.
Yeah.
And then Knight sends another email to Drummond on the 3rd of April that sends the proposed plea agreement. He of course, Glossip had two writs to the U.S. Supreme Court. One was on an earlier PC post-conviction relief application. That one was pending, and no action was taken on it until after the second writ was decided. On February 25th, 2025, the U.S. Supreme Court vacated Glossip's conviction, reversed the judgment of the Oklahoma Court of Criminal Appeals denying that PCR writ. Again, the dissents by Justices Bryant and Thomas are a good read, because they both felt that the Supreme Court overstepped because the record before it was not sufficient to decide the case in the way that they did. So what they should have done is reversed it and sent it back to the Oklahoma Court of Criminal Appeals,
right,
to say, no, you can't do what you did. You have to look at it again.
Yeah.
But anyway, that's neither here nor there. So now it's on remand. The counsel for the state, the attorney general, did agree or did assume jurisdiction. Counsel for the state are Gentner Drummond, Attorney General, Jimmy R. Harmon, Senior Deputy Attorney General, Amy Eli, First Assistant, Jennifer Hinsbarger, and Ryan Stevenson, also Assistant AGs. Counsel for the defendant are Don Knight, Pro Hoc Vice, Corbin C. Brewster, Andrea DeGilio Miller, Judy Clark, Pro Hoc Vice, and Mark Olive, Pro Hoc Vice. And Mark Olive has represented Glossip before.
A long time.
A minute entry was entered on April 24, 2025, setting a status conference in the case for May 9th, 2025, and noting that Glossip had waived his appearance. On June 7th, 2025, Clark and Knight send a letter to Amy Eli, the First Assistant AG. Apparently, an alternative plea agreement had been proposed by the state. I don't have evidence of it.
Oh, gotcha.
I don't have it, but there was a response rejecting it. They were rejecting a resolution of the case that required a life with parole sentence with no understanding of how much time Glossip must continue to serve. It's clear from the court record that Glossip rejected an identical offer in 2003, reiterating their offer to settle the case by way of a plea to accessory after the fact and imposition of the maximum 45-year sentence. And this is good. To the extent the state objects to an Alford plea, Glossip would be open to entering a guilty plea to accessory. So they've discussed an Alford plea.
Okay.
After he got a new trial, not before.
Yeah.
Okay. Yeah. The timing is important.
It's like on the Western 6-3. It's like, why did they ask for the Alford plea after they got the DNA results that they've never shared with anyone?
Correct. And we'll talk about that a little bit later, too. I just didn't have that on my list because it wasn't in my brain. They also allege that Drummond's public and private statements from 2023 to present support their offered resolution and asking the offer to be taken directly to Drummond for consideration and approval. And this is another reason I'll never forgive him, because all these irresponsible statements that he made when he supported Glossip's claims are coming back to bite him in the state of Oklahoma on their asses.
Right.
Because he then, after the conviction's reversed, he says, I'm going to prosecute, and I'm going to prosecute him for first-degree murder. But I'm not going to seek the death penalty this time. So they also say they're prepared to engage in good faith discussions and believe that a resolution is possible if both sides recognize the current state of the record. Please let us know if you believe further conversation at this point would be fruitful. There's another hearing on the 9th, or a status conference on the 9th, in which a bond motion hearing is set for June 17th. On the 9th is also when Drummond put out a press release that basically assumed jurisdiction and noted that he would not seek the death penalty. A motion to reduce bond hearing was held on June 17th, 2025. On July 16th, Knight filed a motion to enforce express agreement reached with the state of Oklahoma and brief in support, alleging that there was a release dismissal agreement between himself and Drummond in April of 2023 that would allow Glossip to plead guilty to a single count of accessory, and wanting the court to enforce this agreement. The state on the same date filed a notice of rejection of defendant's proposed plea bargain. And basically their argument was that there is no constitutional right to plea bargain. A plea bargain standing alone is without constitutional significance until embodied in the judgment of a court. A plea bargain is not binding on either party unless and until the court accepts the defendant's guilty plea or the defendant can demonstrate he relied to his detriment on a plea agreement that was accepted but later withdrawn. Here, contrary to defense counsel's abrupt new theory, the parties have never reached a plea agreement in this matter. Defense counsel premises the existence of a supposedly binding agreement on an email exchange between himself and attorney General Drummond on April 1st, 2023. These emails were sent 5 days after the defendant filed his fifth application for post-conviction relief with the OCCA, nearly 2 years before relief would ultimately be granted. Since the defendant at that time was still under a final judgment and sentence, there was nothing to bargain for. Any prospect of plea bargaining in the event of a vacatur was purely speculative. Not only were plea discussions at most anticipatory, a plain reading of the email conversation reveals that the parties never reached a final plea agreement. Indeed, the purpose of the email was to confirm the basic terms of a proposed agreement before defense counsel prepared a final document for the Attorney General's review. Defense counsel has not provided this court with a final plea agreement executed by the state and the defendant. Instead, counsel provides nothing more than attorney correspondence discussing the future drafting of such a document. And then there are a few other things. But interestingly, they talk about the proceedings that were held between April 2023 and July of 2025, in which the defense never acted as though they had a plea. And then also, he goes on to say, if the defense genuinely believed the parties had reached a final binding plea agreement in this case 2 years ago, then it defies logic that it would continue to engage in ongoing plea negotiations, offering different terms than were discussed in 2023 at that. Seeking bond pending an anticipated retrial, contemplating moving forward with a remanded preliminary hearing, move for admission of additional out-of-state counsel, and appear before this court on numerous occasions without once mentioning the existence of an alleged plea agreement. The defendant cannot show that he reasonably believed a plea agreement exists in this case and that he detrimentally relied to any degree on the mistaken belief that it did. Rather, all communications and conduct by counsel for both parties manifest the understanding that no agreement has been reached to date. Needless to say, the defendant is not entitled to enforcement of a non-existent plea agreement. Though not procedurally necessary due to Knight's announcement that he intends to submit a critical pleading, presumably seeking enforcement of an unfinalized plea bargain long ago abandoned by the parties, the state hereby gives formal notice that the proposed agreement is rejected. Status conference was held on July 1st. An order denying bond was entered on July 23rd, 2025, and basically the judge said, having considered the record, arguments of all parties, and the exhibits submitted by the parties, the court finds the state has sufficiently shown by clear and convincing evidence that the presumption of the defendant's guilt of a capital offense is great. Accordingly, the court finds Glossip's request for bond should be and is hereby denied. Knight has filed a brief in response to the notice of rejected and a reply to the state's response to the motion to enforce, which I don't have. A status conference was held on the 14th. And one of the other problems that we've encountered in this remand is most of the judges in the criminal section of the Oklahoma County Court are former prosecutors with the Oklahoma County District Attorney's Office.
So
even though they never directly worked on Glossip's case, there's an appearance of potential appearance of bias. And so on August 14th, Judge Heather Coyle recused. The case was transferred to Judge Savage. On September 4th, Judge Savage recused. The case was transferred to Judge Stallings. There was a Rule 15 hearing on September 4th seeking Stallings' recusal. That was denied initially, and then a formal motion was filed, and a second hearing was held, and Stallings granted the motion to recuse. That was on October 30th, 2025. Glossip sought random assignment of a civil judge. The case was initially transferred on November 6th to Judge Kirkpatrick. A status conference was held on November 6th. A second status conference was set for December 2nd. The state filed a response to the random assignment motion. Unfortunately, I don't have any of these motions. I do have a few of the orders. The case was transferred on November 20th, 25 to a Judge Trong, um, by Judge Trong for permanent reassignment by Judge Green. And on December 2nd, Judge Ogden set a hearing on the 5th of December to set forth the process for selection of a trial judge to be assigned to the case. The hearing was held before Judge Ogden, and finally the case was finally assigned to Judge Natalie Mai, and she's a judge on the civil docket. She's young, so the chance of her having touched anything related to Glossip's case is slim to none, and Slim done left town. So then a second motion to, pardon?
She might be able to stick it out.
She should be able to preside over the case without complaint by Glossip. A second motion to set bond was filed on December 23rd. There was a status conference on the 29th, and motion dates were set. The state has responded to the motion to set bond, and Glossip filed a reply. On the 23rd of January 2026, there were several subpoenas that the defendant had issued to Steve Harp, Oklahoma District Attorney, and Oklahoma Attorney General, and those entities filed motions to quash, which were granted from the bench at a hearing held on the 23rd. Glossip has filed a motion in limine. They've entered a stipulation on the motion to enforce They continued the hearing on the motion to enforce express agreement. There was a hearing on the 12th for the motion to set bond. That ruling is to be issued after the parties submit proposed findings, and those were due late last week. And I probably won't have anything until the order goes into the record or is posted by some news organization. And then also on the 20th and the 25th, the state responded to the defendant's motion in limine, and Glossip filed a reply to that response. And again, I don't know what they're seeking to limit. Hopefully the order will tell us when it is eventually entered. And I'm still trying to get, for some reason, every other county's records are available, but Oklahoma counties are not, which is really annoying. So, all right. So next we go to Oklahoma versus John Hanson. And his victim was Mary Agnes Bowles. She died September 7th, or she's believed to have died August 31st. I have that wrong. She died August 31st, 1999. Gerald Max Thurman, he was either 44 or 45. He died on September 14th, 1999. He was found and in the hospital for an extended period of time.
And those are both victims.
Oh, yeah. Okay, her date of death is listed as the September 7th, 1999. That's the date her body was found. And think about Thurman. I mean, I don't know whether he was found on the 7th when she was found or whether he was found sooner. It's not really entirely clear. Anyway, Hanson was convicted in 2001, guilty first-degree malice murder of Mary Bowles and first-degree felony murder of Gerald Thurman on May 22nd, 2001. On the 8th of June, 2001, he was sentenced to death and life in prison. His direct appeal, his convictions were affirmed on June 11th, 2003, but his life sentence was affirmed, but his capital sentence was reversed and remanded for resentencing. That was done, and he was sentenced again to death on January 24th, 2006. His sentence was affirmed on April 13th, 2009, after a direct appeal. He had three post-conviction state court writs, all of which were denied, including one where he alleged that he was a member of the Muskogee Creek Nation, that the crime occurred on Indian land, and therefore the state of Oklahoma had no jurisdiction, and only the federal court had jurisdiction, and the federal court did not seek the death penalty. That was denied. He filed a federal habeas claim that was denied on July 1st, 2013, and that was affirmed by the 10th Circuit on July 30th, 2015. He went before the U.S. Supreme Court 3 times, all of which were denied. Then on the 22nd, the December 13th, 2022, the state of Oklahoma was trying to bring Hanson back to Oklahoma for execution. They filed a challenge to the Federal Bureau of Prison Denial. That was denied on December 13th, 2022, and the case was dismissed for lack of jurisdiction. A report and recommendation basically found, and I think that was in a different case. I've confused myself. Okay, the report and recommendation is in a different case, and it's in the wrong spot. Okay, update. We're updating now. Thomas D. Hurd and Emma Rolls, federal public defenders with Western District of Oklahoma, and Callie Heller represent Hanson. She at least represented him before the U.S. Supreme Court. Okay, so when Donald Trump was elected, he put out an executive order that said he wasn't going to let the Bureau of Prisons interfere with executions, and he encouraged the Attorney General. The Attorney General put out a similar memorandum that if they're ready to be executed in their state, then we're going to give them back to the states. And we're going to also we're also going to start doing federal executions again as well, I believe. So Hanson filed a complaint for declaratory relief or a temporary restraining order and preliminary injunction in federal court in the Western District of Louisiana, because the federal prison in which he was being held is in Louisiana, is in the Western District. So basically, he was challenging transfer because the federal government had primary jurisdiction over him because he was serving a life sentence for bank robberies. That he's a citizen of the Muskogee Creek Nation, and the state crimes for which he was convicted occurred on Cherokee Nation Reservation in Oklahoma, which is Indian country, making it under federal, not state jurisdiction. The Attorney General of the United States has the power to transfer, but he has to meet certain conditions, and he alleged that those conditions were not met. So he wanted an order enjoining Hanson's transfer to Oklahoma until he had completed his federal sentence, issuance of a preliminary and permanent injunction, enjoining him from being transferred to the state of Oklahoma, or at least an order enjoining his transfer until the matter could be fully briefed and resolved by the federal court. The U.S. and he sued both the U.S. and the U.S. federal defendants and state defendants, and they filed their oppositions. A judgment was entered. The report and recommendation was that the TRO should be entered. That was on January 31st, 2025. And that, but there was a time to file objections to that recommendation, which was done. And then on February 27th, 2025, the judge rejected the recommendations and did not adopt them, and dismissed Hanson's complaint without prejudice as unripe, and his motion for a temporary restraining order denied as moot.
Hmm.
On March 1st, 2025, he was transferred from Louisiana to Oklahoma State Penitentiary at McAllister at the request of A.G. Drummond. On the 20th, a notice of March, a notice regarding execution of death warrant was filed by A.G. Drummond, requesting the court set Hanson's execution on or after June 12th, 2025. That was done on April 1st, 2025. Hanson then filed in the Eastern District of Oklahoma a new petition for writ of habeas corpus and complaint for declaratory and injunctive reliefs, basically challenging his transfer to Oklahoma. And I'm not going to go into all the grounds and all the claims. The federal respondents opposed that. Hanson filed a response. They also had filed a motion to dismiss, and he responded to that. He filed a motion for stay of execution, claiming he was likely to succeed on the merits and that he would be irreparably harmed absent a stay, that a stay would not affect the respondent's defendants and would serve the public interest. The magistrate judge entered findings and recommendations on May 6, 2025, and basically he found jurisdiction fails because no federal custody exists. Habeas relief requires more than dissatisfaction with circumstances. It requires jurisdiction. No federal official has the power to produce Hanson before this court. Accordingly, the federal respondents are not proper parties. He also found the transfer was a lawful act of executive discretion, that Hanson's challenge basically collapses on statutory grounds because the BOP did comply fully with 18 U.S.C. Section 3623. All the grounds were met. That Hanson could not make a claim based on a change in administration rather than a change in law. And he went on. He said the completion of petitioner's transfer to Oklahoma in 2025 followed years of federal delay, despite clear statutory authority under 18 U.S.C. 3623. So he also said the due process does not protect against transfer between sovereigns. So Hanson, he recommended on all grounds that Hanson was claiming none of them met. And as you can see from the notes, it's quite a lengthy opinion. He also denied the stay of execution, or recommended denial of the stay of execution. Hanson objected. And on May 27, 2025, the district judge entered an order adopting the recommendations. And despite petitioner's well-argued objections, the court's ruling is made without an evidentiary hearing. And it's the order of the court that the findings and recommendations of the United States Magistrate Judge is hereby adopted and affirmed as the order of the court as supplemented by this order. To the extent that the petition fails on jurisdictional grounds, it is dismissed. To the extent that proceeding to the merits was necessary, the petition is denied in all respects. So they granted the motion to dismiss by the federal respondents and denied the motion for stay of execution. A judgment was entered on the same date. Hanson appealed to the 10th Circuit Court of Appeal. And he was denied a certificate of appealability on June 6, 2025. Excuse me. He then went to clemency proceedings, and guess what? He was trying to challenge those.
These guys are they've been before the Supreme Court more than William Jennings Bryan. Jeez.
Yeah. He requested the board that one of the members, Sean Malloy, who was an assistant district attorney in Tulsa County during Hanson's 2006 resentencing trial, recused himself. Malloy did try at least one unrelated case in front of Judge Carolyn Wall, who had presided over Hanson's resentencing. Those were the only grounds. Malloy deferred to the head of the parole board. At their regular meeting on May 5th. Then, when the clemency hearing opened, Chairman Miller denied Hanson's request for recusal of Sean Malloy based on a finding that there was no evidence that Malloy had any personal history or connection with Hanson's case, or that Malloy's participation would be affected by any bias, prejudice, or personal interest. Miller further found Hanson's request to be based on such tenuous grounds that recusal would create an untenable precedent for the board. And then they went on with their clemency hearing, and 3-2 clemency was denied. He filed a challenge in state court and a motion to stay execution. On June 9th, 2025, the judge did stay his execution so that the challenge to the composition of the board could be litigated. The state filed a petition for writ of prohibition and brief in support on the same date. And basically, only the Oklahoma Court of Criminal Appeals has any jurisdiction over executions. And so they wanted the Court of Criminal Appeals to step in and vacate or force the judge to vacate the stay of execution. Of course, Hanson opposed that. The board did file an answer in the state court challenge. And then on June 11th, 2025, the Court of Criminal Appeals entered an order granting extraordinary relief, which said the Court of Criminal Appeals has exclusive appellate jurisdiction in criminal cases and may exercise such jurisdiction as may be conferred by statute. Although
what is
Hanson,
extraordinary relief versus just normal relief?
extraordinary relief is can I look that up at some time and we'll talk about?
No, fair enough.
Or writ of prohibition, where you're trying to stop a court from doing something or force a court or government entity to do something. That's my understanding off the top of my head.
No, thank you. Appreciate it.
So, and this was on a writ of prohibition to tell the judge you can't do that.
Not right.
All right. So they ruled, although the Hanson's underlying challenge to the composition of the board at his clemency hearing may appear at first glance as a civil matter, the claim is criminal in nature and the issue is inextricably intertwined with the enforcement of his judgment and sentence. Accordingly, we find the matter clearly arises out of a criminal case giving us exclusive jurisdiction. And this was against the judge, not against Hanson. Contrary to respondents' view that he had jurisdiction to enter a stay of execution in Hanson's case, under 22 OS 2021 section 1001.1d, we find that provision grants him no authority to do so. Even if it did, entering a stay was an extreme and unwarranted measure, given the unlikely merits of Hanson's underlying claim, attacking the composition of the board at his clemency hearing. Malloy's vote was of no consequence because a tie vote 2-2 constitutes a vote against clemency. So basically, they ordered the judge to they granted the petition for writ of prohibition and directed the judge to vacate the temporary stay, which he did on June 11th, 2025. Hanson filed a petition in error at the Supreme Court of the state of Oklahoma on the 11th, and he sought the appeal to be retained for disposition by the Supreme Court. He also filed a motion to stay his execution pending outcome of appeal. On June 11th, his emergency application for stay of execution was denied by the Supreme Court of Oklahoma at conference on the 11th day of June, and that was by the court. One of the judges, Kuhn, who was joined by Darby, Kane, and Jett, said he would deny the stay based upon lack of jurisdiction. He also filed Hanson, he's not deterred. Claiming that the state withheld material evidence favorable to the defense of key state witness Rashad Barnes' incentive for cooperation, violating Hanson's right to due process under the 14th Amendment of the United States Constitution and the Oklahoma Constitution, that they knowingly presented false testimony from Rashad Barnes, again violating his due process rights under the state and federal constitutions, and that the cumulative effect of these errors that accrued at Mr. Hanson's capital trial and sentencing proceeding to render those proceedings and his resulting convictions and death sentence fundamentally unfair and unreliable, in violation of the 8th and 14th Amendments of the U.S. Constitution and the Oklahoma Constitution. He also sought an evidentiary hearing and motion for discovery and an emergency motion for stay of execution. On June 10th, that the Oklahoma Court of Criminal Appeals denied his fifth application. And they said Hanson fails to provide sufficient explanation why this evidence could not have been discovered until now. And in the footnote, they said Hanson claims the factual basis only became available last week when Worley agreed to sign a sworn statement documenting the alleged deal between his son and the prosecution, which corroborated the related statement provided by Cole, his son, a few days earlier. Hanson states the information was uncovered in the course of the continued investigation undertaken prior to capital clemency proceedings and a scheduled execution. The alleged deal was made prior to Hanson's first trial, making the factual predicate of this claim available for decades. Hanson confuses discovery of a factual predicate with when its discovery could have occurred with the exercise of reasonable diligence. And a lot of defense attorneys have this problem, have this confusion. The state, in its response, questions why the materials were not included in Hanson's clemency process if discovered during preparation for the clemency proceeding that was held May 7th, 2025. They went on to say nothing suggests Worley or Cole were unknown or missing and could not have been interviewed before now, and their claims made the subject of Hanson's previous appeals rather than in this successive post for a crime that is either a drug crime or a gun crime. Because Worley and Cole each say something different. Worley and Cole's affidavits are inconsistent, with Worley claiming the agreement was to dismiss Cole's gun charge, and Cole claiming the deal was to forego charging him with a drug possession. The prosecution dismissed Cole's gun charge over a year before Hanson's murder trial and quashed the subsequent pretrial drug arrest with nothing but the hope Barnes would follow through on his deal to testify against Hanson and Miller strains credulity. Moreover, the evidence against Hanson, irrespective of Barnes' testimony, was compelling. So they deny the Brady claim, which is the withheld evidence. They deny the NAPU claim, which is false testimony, and they deny the cumulative error claim because they didn't find any error. So the successive application was denied. The mandate was ordered to be issued upon delivery and filing of the decision. Hanson filed an appeal and an application for stay of execution with the U.S. Supreme Court on June 11th, 2025. and I'll bet you Glossip is what made him use NAPU.
Yeah.
Um, and I'm not going to go into the grounds because, or the questions presented. The website is available. The briefs are available. If you're interested, you can read them. The petition was denied, and the application for stay of execution was also denied. Uh, Hanson's execution went forward on June 12th, 2025. He was accompanied by a spiritual advisor. His last words were unclear. It's believed he mentioned forgiveness, but the complete statement and context were unclear. He concluded by saying peace to everyone. The drugs were administered at 10:01, and he was pronounced deceased at 10:11. And one of the DOC people at the press conference afterwards said that was one of the fastest executions he'd seen in a long time.
Interesting.
After the execution, Jacob Thurman, Gerald Thurman's son, made a statement. He noted that his mother, Sherry June Brandon Thurman, died in 2021 or 2023 after Hanson including Pam Bondi, the governor of Oklahoma, and the attorney general, who actually did his damn job that time. He said he was starting to feel lighter after Hanson's execution. He also said the experience was the longest nightmare of our lives, and that it's just horrific that everybody loses, that all families lose in this situation. Nobody's a winner. Sarah Parker Mooney, the niece of Mary Bowles, also made a statement. Her mother, who died in 2008, was Mrs. Bowles' sister. Miss Mooney thanked the Tulsa Police Department, the Tulsa County District Attorney, and Attorney General's office. She went on to say capital punishment is not an effective form of justice when it takes 26 years. Respectfully, if the state is going to continue to execute individuals, a better process is needed. This existing process is broken. There must be limitations on taxpayer-funded, frivolous litigation as exemplified in the past 2 weeks. It's ridiculous, it's expensive, and it only re-victimizes survivors. In this case, it served no purpose. When asked what she wished people knew about the death penalty process that they don't understand, Ms. Mooney said how it's funded, who the actors involved are, and what it's really about. It's not about the victim, and I'm not even sure it's about the defendant either. And then Drummond filed a notice regarding execution of death warrant on June 12th, 2025, noting Hanson's execution and seeking a new date for the next person in line.
Yeah, I mean, as a side comment, that's the thing, just like she said, which has kind of seemed or become obvious to me is so much of this stuff is just not about the victim, not about the perpetrator. It's just special interest groups who have millions of dollars and they
Mm-hmm.
just spend it and they don't care. All they want is an agenda. They don't care who they upset. They don't
Mm-hmm.
really care about the I mean, they definitely don't care about the victims and they don't really care about the perps. They just want to, make their political point.
Well, I think it is. I think it's a war of attrition.
Yeah, that's a good way to
And
think
I
about
think they're also using it as a means of propaganda
it. Exactly.
to make people have less confidence in the death penalty overall, and then juries will stop sentencing people to death.
Right.
So, and then when that happens, if there's no death penalty, they'll go after life without parole next.
Yeah, exactly.
So, all right.
Well, and now
So,
they're just going about even profit. Now it feels like many are just going after prosecuting criminals at all.
right, exactly. All right. So, the Oklahoma versus Hanson versus the PPB case was dismissed on June 25th, 2025. And in the motion to dismiss, it said Hanson's cause of action was rendered moot when he was executed by the state of Oklahoma. Next, we have Texas versus Robert Roberson or Roberson. I think there are two alternate pronunciations. I usually say Roberson, but I've heard Roberson, so my apologies if I'm mispronouncing it. His victim was Nikki Michelle Curtis Bowman, who died on January 30th, 2002. He was found guilty of capital murder of a child under 6 on February 3rd, 2003, and sentenced to death on February 14th, 2003. His conviction and sentence were affirmed on direct appeal, and the opinion of the court was that the appellant raises 13 points of error. We find no merit of them, and we affirm the judgment. He has applied to the U.S. Supreme Court multiple times. Let's see, 5 times so far. Each has been denied, including a stay of execution. He's had multiple state post-conviction writs, all of which were denied. He had federal habeas claims, which were denied, and the Fifth Circuit affirmed the denial. He had an execution date on October 17th, 2024, but the Texas Supreme Court granted him a stay of execution based on a TRO granted to the legislature so that Roberson could appear at a hearing and testify at a legislative hearing on November 15th, 2024. The Texas Supreme Court found that the TRO was not proper, and they denied mandamus relief, superseding their October 17th order. The legislators issued a jurisprudence interim report in 2024, but it's based on a one-sided summary of the case against Roberson that continues to propagate the myth that he was convicted based on a diagnosis of cause of death of shaken baby, which has never been the case. Now, something I missed on our last update episode was that Judge Evans, who had been presiding over the case since the 2016 hearings, she recused herself on November 25th, 2024. We don't know why. There was no reason cited. She just recused. The legislature again tried to get Roberson to appear at another hearing by subpoena. A motion for protective order was filed by the TDCJ in Polk County, and nothing was ever done.
Why was the legislator wanting him at the hearing so bad?
I don't know, because he's not, I mean,
It's not.
he never graduated high school. He's not, and basically he's not a smart man. And they
Yeah,
say he's autistic. So he's not a legal scholar. It's not like he's gone, it's not like he went to prison and got his
yeah,
GED and now, he's like a legal savant.
yeah. I just couldn't figure out why they seem so obsessed with wanting him to appear.
But and then on February 19th, 2025, that another one-sided hearing was held on this 21st December. Roberson didn't appear, and they haven't tried to subpoena him again, although I guess they're waiting until he has another execution date, and then they'll subpoena him for 3 days after that. And hopefully the state will follow through on the protective order that says they can't subpoena him at all. But yeah, the protective order, nothing's been done. So the legislators haven't pursued it or sought its dismissal, and the state hasn't pursued an actual order being entered. He filed a fifth I believe, or 6th or 7th. I'm not sure what number it is. It's
Well,
06,
the
but
fact that
that
you
may be the
can't
7th.
remember just shows you how many pills we give them.
Pardon?
I said just the fact that you can't remember just shows how many pills these guys get.
Yeah. Yeah. Well, I don't know. I like there's the first writ and then there's second, third, fourth, but sometimes I think this is numbered 6, so this is going to be 6. Like I said, it's difficult to count, but this is at least the 6th, maybe the 7th. And basically they just, he was entitled to relief, uh, because he's actually innocent. He's entitled under Article 11.073, and he's been deprived of a state-created liberty interest in violation of federal constitutional law. They also allege the court has been misled about the record, and that there wasn't no credible evidence that Roberson was a person capable of hurting anyone. Of course, like the testimony from his ex-wife about the abuse he committed against her, that didn't happen. She's not credible. The abuse of his children, not credible. That's what really this particular case, much like Reed and Glossip, these attorneys are trying to rewrite history and facts. And then they have the gall to say when the state cites the true facts, they have got the gall to accuse the state of lying and misleading the courts. This is another one that boils my blood. So now we go into the update. Roberson is represented by Gretchen S. Swen and Callie Heller, who's with the Western District of Oklahoma Federal Defender's Office. So what she's doing in a Texas death penalty case, I don't know. Allison Mitchell, District Attorney of Anderson County, and Ellen Stewart Klein, an Assistant AG, and an Assistant District Attorney by special appointment, is representing the state. We have some initial pleadings. There was a motion requesting an execution date filed on June 17, 2025. Roberson objected to that. The case was assigned on the same date to the Honorable Austin Reeve Jackson, a judge from the 114th District Court in Smith County, Texas. The state responded to the objection to request for execution date on July 2nd, and a hearing was set for July 16th, 2025. That hearing went forward, and the judge granted the request to set execution date, issuing an order the same date, setting Roberson's execution for October 16th, 2025. Roberson filed a motion for stay of execution in the Court of Criminal Appeals on July 24th. The state filed a motion to dismiss Roberson's 06 application, and Roberson filed a motion to strike that as untimely, and then on August 20th, 2025, Roberson filed a 7th state post-conviction application, claiming that Roberson's conviction was obtained before a tribunal tainted by the appearance of bias, where the failure to recuse caused a structural error and the deprivation of due process guaranteed by the federal Constitution. The appearance of bias and impropriety is now objectively obvious. The appearance of judicial bias and impropriety reflected in the Anderson County Judiciary's undisclosed role in the underlying facts violated Roberson's due process. And this is because the father of the prosecutor appointed counsel to Roberson. I'm not going to go through all these reasons because it's just crazy. And also
Aren't they
claiming
all?
Roberson's actually innocent. Um, then Roberson filed a response in opposition to the state's motion to dismiss, basically arguing that the motion was untimely, that it was exceptionally misleading, saying the state's characterization of the evidence adduced at trial is misleading. The case was tried from beginning to end as a shaken baby case. Well, that's what the defense tried to try it as, but that's not what the state tried it as. The state's characterization of this evidence adduced in support of habeas relief is misleading. Every tenet of the SBS hypothesis put before the jury at trial has been debunked, and overwhelming evidence of actual innocence has been amassed. As with Rodney Reed, what that is, I don't know, because it's just a lot of blah, 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 blah from Gretchen Swen. They found that he argued the motion was otherwise improper because the state seeks to redescribe and nullify Ex parte Rourke. No, they don't. Ex parte Rourke is a shake a baby case. Roberson's case is not. The state's motion does not rely on peer-reviewed science, but instead invokes a biased authority cited in non-scientific media stories. Basically, the state argued that Roberson's experts are a group that are going after shaken baby convictions all around the country, which kind of is brilliant because that would affect their credibility. It shows bias, potential bias. The state responded to the application for a motion for stay of execution and motion for oral argument by saying that Roberson's claims are procedurally barred, and they are because they deal with things that occurred in 2002 prior to Roberson's trial and could have and should have been discovered prior to Roberson's trial and prior to filing of his first habeas application. Roberson replied. Let's see. I'm not going to go into all this stuff because it's not really relevant. On October 9th, 2025, the Texas Court of Criminal Appeals issued a per curiam order, and basically they've thoroughly reviewed applicants' fifth and sixth subsequent habeas applications, including the claims raised in the evidence submitted and in some instances resubmitted, and the entire record, and we find that applicant has failed to show that he satisfies the requirements of Article 11.071, Section 5, Texas Code of Criminal Procedure. Accordingly, we dismissed the 06 and 07 applications as abuses of the writ. We decline to reconsider on the court's own initiative the denial of applicant's 03rd application and the dismissal of the 04 application. On the court's own initiative, we reopened the 05 habeas application, and after finding that applicant's sole claim that ex parte Rourke establishes that applicant is entitled to relief under Article 11.073, satisfies the requirements of Article 11.071, Section 5, we remand the claim to the trial court for resolution. This remand is limited to consideration of applicant's Article 11.07 claim in light of Rourke. The trial court shall not entertain nor address any other claims. Applicant's emergency motion for stay of execution is granted, pending resolution of the claim. Judge Richardson wrote a concurring opinion, which basically agrees with granting the remand on the Rourke claims. And then another concurring and dissenting opinion was entered by Judge Shank. Basically, what he believes is that they should have granted the application, the fifth application, and just let it go to a new trial. And then Judge Finley filed a concurring and dissenting opinion, and he disagrees with the limited um, remand, he would have remanded the actual innocence claims in the '06 and '07 applications. And then Judge Yuri, who's my new hero, he wrote a lengthy concurring and dissenting opinion. And basically, he reiterated the facts that um, he dissents from the order insofar as it reopens the application, the '05 application. Um, and he had very strong opinion. And I'm not going to read the entire thing that I did, but he said, moreover, this case has never been one in which the state relied for applicant's conviction exclusively or even principally on the scientific theory underlying SBS. Instead, the state's predominant theory was that applicant's young daughter was killed by the infliction of blunt force trauma. It was the defense who injected SBS as a theory of what happened in this case. So the claim that applicant's conviction turns on the scientific validity of SBS is manifestly false. With these additional observations, I dissent to this court's order insofar as it opens applicant's '05 writ application and stays its execution. And then Parker also wrote a separate concurring and dissenting opinion. And he states, in fact, shaken baby syndrome was applicant's defense. He tried to convince the jury that the death was inadvertent by relying on the idea that the child could have been killed due to shaking alone. Casting doubt on shaken baby syndrome actually hurts his case because it would make a jury even less likely to believe that the child's death was unintentional. And he goes over extensively the evidence of blunt force trauma. The motion to stay execution was dismissed as moot by order because they had granted the remand. And the motion to dismiss was also dismissed as moot, as was the motion to strike the state's untimely motion to dismiss and motion for reasonable time to respond and motion for oral argument. And then they issued a corrected opinion on October 20th, 2025, which mostly changed the term applicant to Roberson throughout the opinion. There were a couple of other changes as well. On remand, Roberson's represented by Gretchen Swen, Kimberly Mears, Nicole Lefebvre, and Emily Lynn. The state's represented by Allison Mitchell and Travis G. Bragg, who is appointed as an assistant district attorney. There was a motion for status conference filed, which was opposed by the state. And Roberson filed a notice of new persuasive authority, which is a state court opinion excluding some testimony from an expert in shaken baby, a prosecution expert in a shaken baby case. Status conference was held on December 12th. State filed a motion for extension of time to answer on January 30th. Roberson opposed it on October 3rd, but it was granted on October 3rd, and the state's response is due on October 7th, 2026. So there's an evidentiary hearing scheduled for the week of June 15th, but that may not go forward because the state court, the response from the state is going to be filed on the 7th. So that is Roberson. We're waiting for the evidentiary hearing.
And any idea when that's going to be? Is that going to be in like 6 months?
Like I said, it's currently scheduled for the week of June 15th. And they do have the Court of Criminal Appeals is not going to let them wait around too long. But it may not go forward on the 15th. It's going to depend on what else needs to happen before that hearing from Roberson's counsel after the state responds. So now we move on to Texas versus Rodney Reed. His victim is Stacy Lee Stites, age 19, and she was killed on April 23rd, 1996. He was found guilty of capital murder, 2 counts on May 18th, 1998, and he was sentenced to death on May 28th, 1998. His conviction was affirmed in 2000 on direct appeal. He's filed multiple, again, post-conviction writs. Let's see, he filed 2 in 2002, 3, 4, 5, 6, 7, 8, 9, and 10. So he's filed 10. They've all been denied. 2 did have some claims remanded and evidentiary hearings were held, but then relief was ultimately recommended by the trial court to be denied, and the Court of Criminal Appeals also denied relief on the remanded claims and dismissed the remaining claims that were not remanded. He's also filed. There have been DNA testing requests in the case. There was an agreed order for limited DNA testing entered on July 14th, 2014. His formal request for Chapter 64 testing was denied on December 12th, 2014. On February 13th, 2015, YSTR testing from the agreed limited testing matched Reed to do new DNA from Stacy's pants and back brace. The state filed an amended advisory regarding those test results. On April 12th, 2017, the judgment denying DNA testing was affirmed by the TCCA. Reed's writ to the U.S. Supreme Court challenging that was denied on June 25th, 2018. On November 15th, 2019, he filed his 1983 challenge in federal court, was dismissed. And in April 21st, 2021, the U.S. Fifth Circuit affirmed that based on timeliness, which then went to the U.S. Supreme Court. We'll talk about that a little bit later. He's also done several rounds of federal post-conviction. He's been before the U.S. Supreme Court, and his only success was April 19th, 2023, in which the judgment of the Fifth Circuit on the DNA challenge was reversed and remanded to the Fifth Circuit Court of Appeal. It's important to note that the a media outlet reports the federal case, they always say the federal court's going to decide whether he gets DNA testing. The Fifth Circuit, the Supreme Court. That is not the case. The merits of the testing requests are not before those courts and never have been before those courts. What's been before the courts are the civil rights challenge to the state court denial of testing. So yeah, even if the U.S. Supreme Court found he was entitled to DNA testing, it would still have to go back to the state court. And that would be on a state court denial of testing, not on the Fifth Circuit's denial or affirmation of the 1983 dismissal. So just to get that straight. Now, in 2024, Reed had filed a second petition for writ of habeas corpus, arguing that material exculpatory evidence was suppressed in violation of Brady in connection with the relationship evidence and the nature of Fennell and Stacy's relationship, which were claims that he had pursued in a writ in the state court that was denied. They also allege that there was false testimony solicited by the state at Reed's trial from law enforcement and false forensic testimony. They supplemented with that second application with a declaration by Roberto Boiardo, the original medical examiner, that he signed on August 13th, 2012, that was previously rejected by the federal court in Reed's initial habeas claim. Because after the court rejected his habeas claim, he filed a request for rehearing that brought in Boiardo's declaration, which was not found to be credible or reliable or grounds for habeas relief or to reconsider habeas relief. A dismissal order was signed by the judge on June 12th, 2025, dismissing the second or successive petition without prejudice for want of jurisdiction because he needed to get permission to file that petition from the Fifth Circuit Court of Appeal, which we talked about in a prior update. They which my apologies. And a judgment was entered denying that. Now, after remand, the case went back to the appeal of the dismissal of the 1983 claim on DNA testing went back to the Fifth Circuit Court of Appeal. Reed was represented by Cliff Gardner, Michelle Davis, Nicole DeSalvo, Gregory Renzini, Peyton Carper, all of Skadden Arps in Delaware, Parker Ryder Lawnmaid, and Hannah Kahn of Skadden Arps in D.C., Jeremy Patashnik and Sarah Leitner, Skadden Arps in New York, Barry Scheck and Jane Putra of the Innocence Project in New York, Alan Weber at Chipman Brown in Delaware, and Andrew F. McCrae, now with the McCrae Law Firm in Texas. I think he was previously at Skadden Arps. The state's represented by Angela Colmenero, Provisional Attorney General of Texas, Edward L. Marshall, Brett Webster, Josh Reno, Travis G. Bragg, and Matthew Ottaway of the Attorney General's Office, and Gwendolyn Suzanne Vindel as the Solicitor General. Excuse me. I'm sorry, I've got to take a drink real quick. So, Reed proposed supplemental briefing, which was opposed by the state. The Fifth Circuit granted the request for supplemental briefing. Supplemental briefs were filed on July 13th and September 1st, and a reply brief was filed on October 23rd. I'm not going to go into all the arguments because it's kind of repetitive and I'm tired of it. The case was calendared for oral argument on September 23rd, 2024 at 10:30 a.m. That argument went forward. The case was argued for Reed by Parker Andrew Ryder Longmaid, and Gwendolyn Suzanne. He argued on behalf of Reed, and Gwendolyn Suzanne Vidal argued on behalf of Cook, Gertz, and Lux, who are the, I think, warden, DA of Bastrop, and the clerk of court of Bastrop, which doesn't make a lot of sense to me because Reed is challenging the statute, the Texas DNA statute, that these individuals, they're not enforcing it. They're merely opposing his request under the statute. It's the court that's ultimately deciding whether or not he meets the statute. So I don't understand why these people are defendants in Reed's claims because they're not denying him DNA testing.
Yeah, that's weird.
He's being denied DNA testing by the courts.
Right.
So, which is kind of the backwards. And I think a lot of people have the mistaken idea that due process means when you make a claim, you win. And if you don't win, you're being denied due process.
Wait, say that again? Oh, yeah, I see what you're saying.
That people believe that due process means you have to win every time you make a claim. Otherwise, you're
Yeah,
being
due
denied.
process means you get what you want, or yeah, you get your way.
Um, on May 1st, 2025, an order was entered mooting oral argument because it had been held. The motion for oral argument made by Reed. And then the Fifth Circuit Court of Appeal issued their opinion. And basically, they conclude that none of the requirements imposed on Reed by the Texas courts for DNA testing are fundamentally inadequate to Reed's right to post-conviction DNA testing, either on their face or as applied to him, because he would have to show that all three meet the definition to obtain his requested relief. We conclude the district court correctly granted Gertz's motion to dismiss. And they basically found none of Reed's arguments have any merit. Um, so and there is no constitutional right to DNA testing, which is
Right.
what Reed is seeking to get someone to expand Osborne to grant a constitutional right. So the dismissal was affirmed on the merits of Reed's claims or lack thereof, rather than the original timeliness. A judgment was issued affirming the dismissal by the district court, and the mandate shall issue 7 days after the time to file a petition for rehearing expires. Reed did file a petition for rehearing, alleging the panel overlooked all of his arguments and just didn't do their job right, and also sought en banc rehearing, um, basically arguing Constitution's due process guarantee protects state-created liberty interest in proving one's innocence using newly discovered evidence, including through DNA testing, and that Chapter 64 violates due process. On June 3rd, 2025, the court issued a per curiam order denying panel rehearing and denying en banc rehearing. Judge Andrew S. Oldman did not participate in the consideration of the rehearing en banc. The mandate was issued on June 3rd, 2025. Reed has filed an appeal with the U.S. Supreme Court. The question presented is whether Chapter 64, as authoritatively construed by the CCA, violates due process by arbitrarily denying prisoners access to post-conviction DNA testing, rendering illusory prisoners' state-created right to prove their innocence through newly discovered evidence. And he cites various reasons to grant the writ. An amicus curiae filed a brief in support of Reed. He is a former analyst with the Texas DPS. And basically, he's arguing that contamination can only be detected after DNA analysis. Because the problem is, and again, this is where they're trying to rewrite history to benefit Reed. Reed wants to test the belt, which is the quote murder weapon, unquote. The method to be used is going to be touch DNA, but the belt was handled without gloves during trial, and then it was put into a box with other evidence, so there's a potential for contamination. The problem is that without a DNA profile from everybody who handled that belt, you're not going to be able to identify. For example, you'll have an unknown male that could have been another juror. But if you don't have his DNA profile to determine that, then you've got an unknown male, which Reed would try to use as saying, see, I didn't kill her because my DNA is not on the murder weapon. The other problem for Reed is that no results on that belt are going to change or refute the DNA evidence inside Stacy's body, in her panties, on her breasts, on her belt, and on her pants, on her back brace and on her pants, rather. Significant DNA evidence, two items which were found after the limited agreed testing was done. Those didn't exist at the time of his trial. So no result on that belt is going to change. It's not going to exculpate Reed. And I can promise you, if they find his DNA, they're either going to argue contamination, planting, or they're just going to say, well, he touched the belt because they were having an affair that he's
Yeah,
never
exactly.
proven. And
I
then
mean,
they're
for
going
what
to
it's worth,
fixate on some other piece of evidence and
right.
say, we want to do testing on that now.
For what it's worth, Reed is like the absolute most guilty of any of the cases we've ever covered. Like, I'm actually shocked that anybody could think he's not guilty.
Yeah. And people, and what alarms me is that people don't see the hypocrisy of the Innocence Project,
Right.
who are
Well, the Innocent
trying to
Project.
get him a new trial and trying to get him DNA testing when there is a significant amount of DNA and an absence of any reliable, credible proof of a relationship with Stacy.
Yeah, Reed is the only case where there's even like the normal the normal special interest groups even are like, okay, I'm not touching this one. He's definitely did it.
Yeah,
But yeah,
and
but the
so
Innocent Project's all about taking money from people that don't have really great critical thinking skills.
it's one way of putting it. Uh, so the state has opposed that. The federal record has been requested by the court, and that was filed on September 15th, 2025. The case has been scheduled for conference multiple times. Most of them have been rescheduled. It was last scheduled for conference on March 6, 2026, and the record is silent since then. So I don't know whether it was conferenced and now we're waiting on a denial or a granting of the writ, or whether the can has been kicked around down the road yet again. So that is where Reed's case stands. West Memphis 3 Post-Alford DNA testing.
Speaking
Uh,
of guilty,
the,
oh hey
I think
Luce, I think we oh
am I back?
I think
Did
you're
it?
back.
Okay. I'm sorry. Have I been cutting out?
No, just that one time. I think you cut out right when you were about to
Okay.
right
My
at the
coworker believes they're guilty. I was so pleasantly surprised, um, because it's very unusual for that to happen.
right.
The victims were Steve Edward Branch, age 8, Christopher Mark Byers, age 8, James Michael Moore, age 8. They were murdered on May 5th, 1993. Jesse Miss Kelly was convicted in February 1994 after a trial in Corning in Clay County, Arkansas. He was convicted of 1 count of first-degree murder of Michael and 2 counts of second-degree murder of Steve and Chris, and that was based on his admission that he grabbed Michael and brought him back to the other 2, Eccles and Baldwin. Eccles and Baldwin were convicted in March of 1994. Their case was tried in Jonesboro and Craighead County, Arkansas. Eccles was convicted of 3 counts of capital murder and sentenced to death. Baldwin was convicted of 3 counts of first-degree murder and sentenced to life without the possibility of parole. And their convictions and sentences were affirmed respectively in 1996 and 1997 for Miss Kelly in 1996 and Eccles and Baldwin in 97. Eccles pursued Rule 37 claims, which were denied. His federal writ of habeas corpus was stayed pending the outcome of a motion for new trial in state court. On August 19th, 2011, Eccles, Baldwin, and Miskelly appeared in court and entered Alford pleas, which included an acknowledgement that the state possesses sufficient evidence to convict them at a new trial. At that time, they did have motions for new trial pending and an evidentiary hearing scheduled, but prior to in July, after some additional testing that the results of which we don't know was done, they approached the state with the Alford plea proposal that would have them pleading guilty under Alford, so they can say their innocence and they didn't have to allocute, but they
Yeah,
have to acknowledge there's sufficient evidence to prove their guilt at a new trial.
to me that is the most. I know it's post trial, but to me, if you just think about not legally, but just mentally,
Mm-hmm.
the most compelling thing is of their guilt is the fact that they were pursuing an appeal, they were doing all this work, and then they get these DNA results. They don't share them with anybody, and then suddenly they ask for an Alford plea and drop their appeals. And I've
Mm-hmm.
had all these people online say, "Oh well, blah blah," But at the end of the day, right? To me,
Right.
that's the most
Well,
compelling thing of their actual guilt. Again,
yeah.
not
The
talking legally, just saying the fact that I'm, completely convinced they did it is that fact.
Yeah. And, the excuse often given is, well, a new trial would have taken years. No, it would not, first. But second, they hadn't gotten a new trial. I could see if the motion for new trial had gone forward and the judge had actually granted them new trials because the DNA evidence that they were presenting was compelling.
Well, I would
But
take a step
that
back
hadn't
and say,
happened.
but I would
That had not
separate those.
happened.
Yeah, well, I would separate this too, Lisa, because I would say they could have asked for the Alford plea a year before. I mean, they like the Alford plea and the DNA results are tied together. Like they could have asked for the
Right,
Alford plea
right.
before they started the appeal. I mean,
Yeah.
it's like that's just a complete false argument. But because it's
Well,
like they could have done that long before.
you have to remember too, and this is the other thing that kind of pisses me off. They did come up with the Alford plea after Brent Davis ascended to the bench and Scott Ellington came into office. Because if they'd gone to Brent Davis with the idea of the Alford plea when these hearings were scheduled, he would have said, "Let's see what happens after the hearing."
Gotcha.
And Ellington was going to go forward with the hearing. He was going to use it as a method of discovery.
Right.
So which is why I've always suspected that he did not have the DNA results that prompted the defense to come up with the Alford plea in the first place.
Right.
But that's neither here nor there. They entered the Alford plea, and the Alford plea includes an acknowledgement that there is sufficient evidence to convict. So, and they waived their rights to sue the state for wrongful incarceration.
Well, yeah. And I mean, the last thing I'll say about the DNA results is why haven't they released them? I mean, you got the
Yeah,
DNA results. Why haven't you released them? Because
yeah.
even if it was non-conclusive, even if it was, oh, we don't know
It
who it
doesn't
is. It doesn't
exclude one
match
or the other.
anybody.
Yeah.
That would play into it
I
was a truck driver. It
I
was,
have
John Wayne Gacy. It was
yeah.
Israel Keys, whoever it was, theory.
I have always suspected that something did not exclude Eccles, Baldwin, and or Miss Kelly.
Yeah, that's my 100%. It has to.
Because that
That's
ends
always my thing.
that
It,
ends their
it, it
DNA
implicated one
claim.
of them or all of them.
Yeah. So then in 2022, Eccles tried to get DNA testing done again using MVAC. The state court denied his request. The Arkansas Supreme Court reversed that with one dissent on the update. This is in the Circuit Court of Crittenden County, Arkansas, Western District. Docket number is 18 CR-93-516, and that is in the Second Circuit, Division 6. The judge is the Honorable Tanya M. Alexander, Circuit Judge, Second Judicial District. The attorneys for Eccles, Baldwin, and Miskelly are Patrick Benka, J. Blake Hendricks, and Jeff Rosenzweig, respectively. Sonia F. Haygood, the prosecuting attorney of the Second Judicial District, is representing the state. She apparently, after or before the Supreme Court, Arkansas Supreme Court decision, she had actually, I think, been in negotiations for DNA testing with Eccles counsel, and they're bringing Baldwin and Miskelly in because they have to. But if it were up to Eccles, he would ignore those two. The Arkansas Supreme Court mandates issued on May 20th, 2024. A year and 1 month later, they sought a hearing with the state court on, and a notice of setting was issued on June 24th, 2025, setting a hearing on July 23rd, 2025. An amended notice came out 2 days later on the 26th, setting a second date of August 1st, 2025. That hearing went forward. The state defense attorneys entered into agreed order, which will be filed with the clerk's office today. And they entered an agreed order for DNA testing. Now, first of all, they are testing the ligatures, but then the rest of the testing is hairs. You can't do MVAC on hairs. They're not testing any of the clothing. They're not testing the wallet, the badge. They're not testing any of those physical items. The only physical evidence that's being tested are the ligatures.
Well, and
And
that
then they're
goes to another.
retesting hairs that they've already tested that weren't suitable for nuclear DNA testing, that could only be tested with mitochondrial DNA testing, most of which were found to belong to the victims. And one of the things, I put all the requirements in here, but one of the things is that upon completion of its testing and analysis, BODE shall reduce its findings to a written report, which shall be provided to the Office of the Prosecuting Attorney and to counsel for Eccles, Baldwin, Miskelly, and the Innocence Project. Copies of these reports shall be filed with the court as well. And everybody's reserving rights to challenge the materiality or the relevance of some of these DNA results. And the disputes shall be submitted to the court for adjudication upon written motion by any party. There was an agreed order, and that was basically supplementing the step-by-step packaging, sealing, and documenting of the process to ship the evidence, which could not be taken by a courier from Arkansas to BODE in Virginia. And now it's going to be shipped FedEx at the cost of Eccles, Baldwin, and Miskelly. There was an article on KATV on November 14th, 2025, that the evidence had been sent for new DNA testing to BODE laboratories in Virginia. The evidence may be destroyed in the process, and in that agreed order, Eccles, Baldwin, and Miskelly acknowledged that, and there are certain things that BODE has to do before testing that's going to be destructive. They have to let everybody know. And DNA results, according to Rosenzweig, will likely come out next year, which would be toward the end of 2026.
Well, and I think the biggest thing of this is like, why don't they want to test everything? Why are they only selectively testing
why
stuff?
are they only testing ligatures and hairs that they've already tested?
Yeah, I mean, why not test everything?
Yeah,
I guess they're not that interested in finding the truth.
right. So, and that was supposedly what they wanted to do, was test everything, test the clothes with MVAC, because that could pull DNA that couldn't previously be found. But they're only testing the ligatures and hairs that they've already tested.
Because I mean, let's be honest, this is all just a publicity stunt because no one's
Mm,
paying that much attention, and they're running out of money, and no one's donating to, what does he do? Is he karate now? He gave up on the casting
I
spells. Now he's doing
yeah, I
karate.
don't know. I don't
We
know.
should call him. We should call him Michael-son, in honor of the
No, we
Karate
should not.
Kid.
No, we
He's
should not.
it's Karate Kid 5. Michael Hutchison wins the massive tournament for Cobra Kai.
Alrighty, so let's go. We're in the home stretch, and these next few cases aren't very detailed. Arizona versus Jodi Arias. Her victim, Travis Victor Alexander, age 29, was murdered on June 4th, 2008. She was convicted on May 8th, 2013, guilty of first-degree premeditated murder at the aggravation phase. Verdict on May 15th, 2013. She was found to be eligible for the death penalty. An aggravator was found. Sentencing phase on May 23rd, 2013 ended in a mistrial. Her sentencing retrial ended in another mistrial on March 5th, 2015, which resulted in her being sentenced on April 13th, 2015 to natural life in prison with credit for 2,463 days. And the judge ordered that she's not to be released for any reason for the remainder of her natural life. On June 22nd, 2015, the judge entered a restitution order ordering her to pay restitution to Travis Alexander's siblings. The total amount was $32,115.62. The largest awards were to Samantha and Tanisha Alexander, who were the family representatives during most of the trial phase. So they had to invest a lot more time and travel from California back to Arizona. And then his sister Hillary, brothers Stephen and Dennis had smaller awards, but they, again, did not participate in the trial as much as Tanisha and Samantha did. Her direct appeal was affirmed on March 24th, 2020. And on April 21st, 2020, a memorandum decision was also issued, again, affirming other aspect. It's really weird. I think they looked at two different aspects of her overall direct appeal, and they affirmed one in March and the second one in April. She is pursuing state post-conviction in the Superior Court of Maricopa County. The docket number is 2008-0311021-001 DT before the Honorable Ari D. Schwartz. She's represented by Christopher Stavros and Amy Pickering Knight on the record. There may be other attorneys involved. The state's being represented by Philip Daniel Garrow. They're the ones who've appeared at the status conferences. A minute entry was entered on August 21st, 2025. She's seeking records and time to file her post-conviction relief petition, and that was granted. So she has a firm deadline of September 2nd, 2026 to file her petition for post-conviction relief. And the defense is saying that it can file the petition in less time and it will be filed accordingly. She's got a blog on Substack called Just Jodi. I'm not paying for that, but some portions are public. She's apparently claiming that important exculpatory evidence in her case had been lost or destroyed. She's allegedly working on the proof of that, but her lawyers yawn when I explain this. After all, I'm just the mentally ill woman they have to entertain for half an hour by phone every few weeks, after which they will bill the county. So this is a quote from her, and it's typical Jodi bullshit, Detective Flores or some other henchman acting at Juan's behest likely destroyed or disappeared this exculpatory evidence. Maybe one of them will gain a conscience and admit to their tampering. And then she complains that an attorney has violated her confidence and shattered the trust she placed in them. Over the years, she's helped enrich this person with a lot of my money, and happily so because they were amazing. It's not her money, it's the county's money. And she just goes on. She's claiming she's going to go federal court after her PCR is unsuccessful. But it's been 5 years. It's been 5 years since her direct appeal. So, and then there is a true crime Arizona documentary called Obsessed, Unraveling Jodi Arias, which you can find for free. That's Jodi. Typical bullshit. Are you still there? Are you awake, Kyle?
Yep, still here. I was just on the mute listening to the great Jodi Arias.
All right, so now we're going to go to Florida versus Dalia Dippolito. Her victim was Michael Dippolito. She tried to have him killed. The culmination of her crimes occurred on August 5th, 2009, but the first act in furtherance of the crime occurred on August 1st, 2009. Her first trial ended in a guilty verdict of solicitation to commit first-degree murder on May 13th, 2011. Subsequent to that, she was sentenced to 20 years in Florida DOC, and that should actually be a separate entry because that was done on a separate time. I'll fix that next time. Her direct appeal on July 30th, 2014, the judgment was reversed in part and affirmed in part, and the matter was remanded for a new trial. And this was because during jury selection, the jury, a potential juror mentioned that Dalia had tried to poison Mike with a tea. The jury was exposed to that, and the court found that the jury verdict was unreliable because of it. That's why they reversed and remanded. Jodi's attorneys then filed a motion to dismiss the case against her, alleging outrageous conduct by the Boynton Beach Police Department because they had cops filming. And the allegation is that they manufactured the crime for the cops' TV show. And once again, this is a case of Brian Claypool trying to rewrite history and ignoring that Mohammed Shahade went to the police on July 31st, 2009, saying, hey, this girlfriend of mine is trying to find somebody to kill her husband. And she's tried to poison him. And, they ignored the history that didn't help them. And then they tried to make it look like, Dalia was a domestic abuse victim and that the police were supposed to help her. And instead, they manufactured this crime for cops. So that was denied. They tried a petition for writ of prohibition to prevent the prosecution. That was denied on August 17, 2016. Her second trial on December 14, 2016 ended in a mistrial because the jurors were split 3-3. So 3 thought she was guilty, 3 thought she wasn't. Leading up to the third trial, there was an attorney gag order entered by the judge. She appealed that to the 4th DCA. They denied, and they affirmed that she tried to go to the Florida Supreme Court, which denied her petition for review. Third trial verdict on June 16, 2017, She was found guilty of solicitation to commit first-degree murder with a firearm. She was sentenced on July 21st, 2017 to 16 years in Florida DOC with 163 days credit for incarceration prior to imposition of her sentence. She had filed a motion for rehearing and rehearing en banc for certification of a question of great public importance to the Florida Supreme Court. That was denied on August 16, 2017. A petition to the U.S. Supreme Court on the attorney gag order was also denied on January 8, 2018. Her direct appeal, her conviction and sentence were affirmed on March 19, 2019. She filed a motion for rehearing and rehearing en banc. That was denied on June 5th, 2019. The Florida Supreme Court refused her petition for review on September 4th, 2019. And a petition for writ of certiorari was denied on December 3rd, 2019. Her conviction and sentence became final on February 24th, 2020. She filed a petition to the U.S. Supreme Court. That was denied on the 24th of February. So her conviction and sentence became final. She filed a petition alleging ineffective assistance of counsel, which was denied on May 31st, 2021. And then on August 5th, 2022, her motion for post-conviction relief was denied. And that was affirmed by per curiam of the 4th DCA on March 16, 2023. She filed a petition for writ of habeas corpus in the U.S. District Court of the Southern District of Florida, docket number 23 CV 81027, on July 13, 2023. I'm not going to go into all the grounds. Basically, she argued the ineffective assistance because of the poisoning allegation that was brought before the jury, and that the defense attorneys didn't seek to limit, get a limiting instruction, and then the allegations about a sleeping juror. She had 10 grounds. All 10 were found to be without merit and denied in a report and recommendation issued on April 22nd, 2025. And basically, the magistrate judge found a very careful review of the entire record established that petitioner's claims are meritless and due to be denied for the reasons stated above. No evidentiary hearing is necessary or required. The petition fails to establish any grounds for relief. Accordingly, the undersigned United States magistrate judge recommends that the United States District Judge deny petitioner's petition and deny a certificate of appealability. Dippolito filed an objection on May 5th, 2025 to that report and recommendation, basically arguing her 10 points. And on May 7th, 2025, an order adopting the report of magistrate judge was entered. This cause comes before the court on Magistrate Judge William Matthewman's report issued on April 22nd, 2025. I have conducted a de novo review of the report, objections, and the record as a whole. Upon review, I agree with Magistrate Judge Matthewman's conclusion that Dippolito's habeas petition should be denied. Further, I agree with the report's finding that no certificate of appealability should issue. And a judgment was entered in favor of respondent and closing the case and denying all pending petitions as moot. That was also on May 7th, 2025. So that's Dalia Dippolito's federal habeas has been denied. She did not appeal to the 11th Circuit Court of Appeal, nor did she seek a certificate of appealability from them or a writ to the U.S. Supreme Court. So that's final. There was a post from Brian Claypool on Facebook saying he's working on her federal habeas, but that is false because her federal habeas is over with and relief has been denied. So now we just have some miscellaneous ones. Maryland versus Adnan Syed on May 14th, 2025, his request for sentence reduction under the Juvenile Restoration Act was granted, and his life sentence was reduced to time served. David Sanford, an attorney representing the Lee family, said the family understands the court's decision and respects it. Sanford went on to say there's really no clear path for Adnan Syed to claim innocence. But what we know now is what we've known all along, that there is nothing new here to be seen. Adnan Syed was convicted by overwhelming circumstantial and direct evidence. So
And he's another one. I mean, not only did he start, I think probably started the whole true crime genre, right? With Serial and,
no,
but
not really.
also very guilty.
Yeah, no, I don't think so. There were there were other podcasts, but I think maybe he was the first. He was the first innocence fraud podcast. I'll give
Yeah,
you that.
yeah, fair enough.
I'll give you that. Texas versus Melissa Lucio, her findings of fact and conclusions of law recommending relief be granted to Lucio on her first subsequent application for writ of habeas corpus were issued by the trial court. The supplemental record was received on November 12th, 2024, but as of October 17th, 2025, the Court of Criminal Appeals has taken no action. Lucio has filed a motion to expedite, but nothing has happened on that. The Texas Court of Criminal Appeals is the ultimate final word on whether she'll actually be granted relief. They could grant her relief or they could deny relief and take apart the findings of fact and conclusions of law, which they've done in other cases, but that hasn't happened and it's been more than a year. Tennessee versus Janet Hines. Her victim was Nicholas Gallinger. Oh, and in Syed, the victim was Heyman Lee. Lucio, the victim was Mariah Alvarez. Nicholas Gallinger was Janet Hines' victim. She had a parole hearing on February 4th. May Beavers, a member, voted to deny parole, and on February 10th, 2026, the board made the decision to deny parole. That was finalized. Her next case review will be in February of 2027. Maryland versus James Kolbicki, as of March 10th, 2026. His appellant's brief was filed in the appellate court of Maryland, so he's appealing his third conviction of the murder of Gina Newslin. I'm sorry, Newslin. Texas versus Romeo Pinkerton and Daryl Hartsfeld on November 21st, 2025. A press conference was held revealing new DNA results. The victims in that case were Opie Hughes, Joey Johnson, Monty Landers, David Maxwell, and Mary Tyler. And after 42 years of investigation, law enforcement officials have identified the last perpetrator in the abduction and murder of 5 Texans in Rusk County, an event known to many across the country as the Kentucky Fried Chicken KFC murders. The perpetrator, Devin Riggs, had died years before being identified, so no arrests will be made. And Riggs died on October 8, 2010, according to Lisa Tanner. In 2023, the Texas Rangers identified the case as being eligible for testing and comparison through DPS's Sexual Assault Kit Initiative, SAKI program. The program is funded by the Department of Justice Bureau of Justice Assistance, which provides investigative funding for agencies across the United States to further unsolved sexual assaults and sexually related homicides, aiming to bring justice to the victims and their families. In July 2024, the last piece of DNA evidence taken from Hughes's clothing was sent to Bode Technologies for additional advanced DNA testing and genealogy. In May 2025, this testing led to the identification of one of 3 brothers living in East Texas as a potential suspect. Finally, in November 2025, after further research and additional DNA testing, investigators received a positive match and identified one of the brothers, Devin Riggs. Riggs had been deceased for more than a decade and no arrests were made. Let's talk about that one, because that is, I'm hoping that we'll have another Reed hit.
What do you mean to read
from
hit?
that they'll be able to do this program will be used to find another Reed hit.
Yeah, hopefully. Yeah, I mean, that's a case that hits close to home for me. And that was a new when that tr- that case has been going on for years. I think it was what, 84, 82.
Yeah.
And
Yeah.
when it was weird because the prosecution, in a probably a pretty big mistake, just sort of let it out in open court without telling the family that one of the victims had been raped, and they found DNA. And it was they had the two folks that they had convicted, but then they had this third
Mhm.
person with DNA, and they finally tested that third DNA.
Mhm. Yeah. Well, I think they yeah, but I think it was because I remember when I was researching Harsfeld and Pinkton, Romeo and Daryl,
Yep.
um, that I don't think that they couldn't do DNA in 80s at the time, and then they had unknown DNA when they identified Hartsfield and Pinkton with DNA from inside the store.
Yeah, that's exactly right. They had blood on, I think it was a napkin. They had
Yes.
a couple of things of blood from the store on a napkin. So for the you guys that haven't heard about this case, they basically they robbed the KFC, and then they took the five folks that were there, they took them and they took them about 10, 15 miles away to an oil lease out in the country, and that's where they executed them. So
Mhm.
yeah, they found the DNA in the store that matched Hartsfeld and Pinkerton, but then they had semen on one of the victims at the oil lease, which was again a few, 16 miles
Yeah.
away. And so they identified the first two guys. That's how they made the original convictions. And then it was a while, I think that was in 2008, 12.
Yeah.
And it was a bit before they did the final DNA.
Yeah. Yeah. And Hartsfield died in prison. Pinkton is he's been up for parole. He's been denied, and he's up for parole again. I think in like 2029.
Right. That sounds right.
So, so yeah, that is, and it's good. At least they have some answers. And I think when the DNA came out, um, they had unknown DNA, and Hartsfield and Pinkton wouldn't name anybody.
Right.
So,
And
they
I
couldn't.
think I forget the general I well sorry, I forget the other guy's name, but I think he was like a distant cousin of one of the other two.
Devin Riggs.
Yeah, I think he was a
Yeah.
distant a cousin of one of the other guy of Hartsfeld or Pinkerton.
I'll look more into him. I didn't I was running out of time for this episode, so I didn't go any further than the DNA, but I'll look up a little bit more next time we do updates. We'll talk more about who Devin Riggs was.
Yeah. Well, and the two guys that were convicted have always, claimed innocent, but the
Their
third
DNA
guy,
was
he
inside the
kind
store.
of fits the profile. I mean, all together, it kind of like affirms that, yeah, they probably did it.
Yeah. So, well, I think it was like a cup and a napkin with blood on it
That's exactly,
inside the
yeah,
store, and that was
exactly.
Pinkerton and Hartsfeld.
Yes,
So
exactly.
they were there during the robbery.
Yeah,
That placed them there during the robbery.
exactly. And then an eyewitness had identified folks that look like them who were getting food, before the robbery. And I think
Right.
everybody's expected that they overheard, one of the workers talking about how much money they had in the safe.
Yeah. All right. And then we have Florida versus Ashley Britt MacArthur, victim Taylor Ashley Turcott Wright. On November 4th, 2025, the state attorney was ordered to file an answer to MacArthur's motion for post conviction relief within 60 days. On January 8th, 2026 and March 9th, 2026, the court granted the state attorney's request for additional time. So the state attorney's answer is now due on May 8th, 2026. So Ashley MacArthur's post-conviction claims are proceeding. And once they're decided, we'll probably do an update episode or a follow-up episode on her case. Florida versus Doris Donegan Moore, her victim Abraham Lee Shakespeare. On October 6, 2025, the state court denied a post-conviction relief to the Second District Court of Appeal was affirmed, and the Florida Supreme Court denied Moore's request for review. Moore is unrepresented by counsel and is still proceeding pro se, and she has not yet filed a petition for habeas corpus in federal court. And she probably is going to file too late if she even does. On October 6, 2025, the court dismissed a motion to compel defense counsel to surrender the case file that she'd filed on September 11th, 2025, basically finding that she had not proven specific documents that she was requesting. She hadn't filed her request to the entities that they were not responding, and so the court denied her request. And that's basically it. The rest of the cases that we've looked at, just there's really nothing new since the last time we talked about them. I know I'd mentioned Warmus, but there's nothing new on her case. She was released for medical, reasons back the last time we talked about her. So
that's still a lot of updates.
Yeah, that was a lot. I know. I'd say we are, because we're past the 2-hour mark now. I've got I don't have a complete list of cases we're going to look at in season 5. Message me on Facebook, message me on YouTube. A few of the cases that I do have on the list are State of Missouri versus Marcellus Williams, State of Missouri versus Charles Erickson, and State of California versus Scott Lee Peterson, which is probably going to be a couple parts. But he keeps filing these damn state habeas claims. Every time I think he's done, he files a new one. So those are just some of the ones that we're looking at. But yeah, I mean, Ziegler got a new trial, so I don't want to look at his case yet. The guy in Michigan, Scott Frederick Friedler, I think his name is Temu Kinson. He's going by some Japanese-esque name now, because he's enlightened.
But Temu.
And,
Temu's caused all kinds of hysterics on social media. That'll be a fun case.
Yeah, I haven't had the intestinal fortitude to follow through on that one. It's been on the list, but I haven't been able to follow through. But I may follow through. And then I'm also trying to line up a coworker is a former prosecuting attorney with the in Louisiana. And I'm going to try and get him on as a guest. But he's a little wary, so I have to work on him. So I'm going to send him
we have great confidence in your powers of persuasion. Yeah,
I know. I will eventually persuade him. And he can't be any ruder than Ken Kratz was. So no, he's a very nice, personable guy. So I know it'll be a good one. All right, so we ready to call it?
Yeah, sounds good.
All right. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you like the show and you want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLN. Kyle and I will return in 2 weeks for episode 5, State of Missouri versus Marcellus Williams. We'll look at the 1998 murder of Felicia Gale during a burglary committed by Williams. In spite of strong evidence of Williams' guilt developed during the investigation and presented at his trial, which included testimony from a former girlfriend who saw Williams wearing a shirt covered in blood on the day of the murder, and the man who bought Felicia's laptop from Williams, the St. Louis County Prosecutor's Office sought to vacate Williams's murder conviction and opposed his execution on September 24th, 2025. I'm sorry, I'm laughing at my inability to speak now. We will talk about the case against Williams and his direct appeal and post-conviction claims in state and federal court. We'll also talk about the DNA results that were falsely held out to exclude Williams as the perpetrator of Felicia's murder. Until then, have a great 2 weeks and stay safe.
That's cute.